Judge said she'll be on in 5 minutes.
All right, everyone. Good afternoon. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams. And at this calendar today, we will set bonds for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, please be advised you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. When I ask if you understand your rights, that is what I'm referring to. As you can see, I'm conducting this hearing over the internet. It's being broadcast as a live stream. It's also being recorded. That means any member of the public can log on and watch. Those who receive the signature bond will be reset for the notice. Those who receive surety or cash bonds will be going to the state all-purpose calendar on March the 13th, whereby aspects of the case, including the bond I set today, may be revisited. Are there any announcements or things I should know before we forge ahead? This is a very long calendar today.
We do have two waivers.
Okay. Have all defense attorneys had the opportunity to interview their clients?
Yes.
Yes.
Your Honor, I have one that was still in felony first appearance. Last time I checked, just a few minutes ago still, which is Mr. Hearns. Let me see what position he is.
He's position number 9.
9. Okay, so we'll need to interview 9 when possible. Okay, we will begin. Who do we have first?
Position 10, bond was paid.
I'm sorry, say that again.
Position 10, bond was posted. This is an announcement.
Oh, Ron was posted for 10, 10 bonded out. Thank you.
And we're starting with position number 25, and she has private counsel.
All right, counsel, will you enter your appearance before I hear your argument?
Absolutely. Good afternoon, Your Honor. My name is Frederick Mann. I'm with the law firm of Matthew Hines here in Atlanta, and I represent Miss Irene Soroeta, spelled Soroeta.
Thank you so much. Ms. Sortoreta, your case is 25 CR 001071B. In this case, you are charged with two different counts, battery, family violence, and cruelty to children in the 3rd degree. Do you understand your rights today?
Yes, I do.
All right. Mr. Howard, can I please have the history of position 25?
First arrest. Hold on, let me see something. Yeah, I got first arrest.
Okay, I'm sure Ms. Mokake will chime in if she has something different. Ms. Mokake, please proceed.
Yes, Your Honor. Good afternoon. I don't have anything different. This is her first arrest, from what I've seen as well. This incident happened on the 28th. I have that the incident location is 5920 Long Island Drive in Sandy Springs. The victim in this case is Francisco Garcia. The defendant is accused of pushing the victim to the ground during a verbal altercation, causing him to have a bleeding laceration on his foot. The 911 call was made by the party's daughter, Natalie Sorietta. Officers did note that when they arrived on scene, the defendant appeared to be intoxicated. Miss Natalie Sorietta told officers that her 9-year-old son had come and told her that something was happening downstairs. When she went downstairs, she did observe her mother push her father down. Miss Natalie's son also recorded 2 videos of the incident. In one, you can see the defendant on top of the victim, keeping him down while he was attempting to get up. Given that this is her first arrest, the state's recommendation is for a signature bond, but we would ask for no further contact with Francisco Garcia, stay away from the incident location, no drugs, weapons, or alcohol, and that she undergo some anger awareness. And I would ask the court to sound for Mr. Garcia.
Has your office made contact with Mr. Garcia?
We have not, Your Honor.
Okay, is Mr. Garcia present?
He's in the waiting room upstairs, Your Honor, or in the lobby.
Okay, does he wish to make a statement now?
No, but he's spoken to me and was the one who contacted me. He doesn't want to press any charges, and the injury that he sustained briefly,
Is it possible for him to be brought for a moment just to verify for me that he wishes to have contact with her? Is that possible at courtroom 2 if he's in the lobby?
Absolutely. But he's sitting in one of those bucket chairs in the lobby.
Understood. I just want to make sure. I want to hear him say, she want her to come back home. But please proceed with your argument while we see if we can make that happen.
Wait, first of all, Judge, this is a very distinguished lady. She is 68 years old. I'm sorry, 58. I'm in big trouble now, Judge.
You really are, counsel. You really are. That's not cool. All right, continue.
I'm 72, so you'll have to make some allowance, okay? But no, she is a graduate of Harvard, cum laude, and also a graduate of Boston College Law School. She was the solicitor for the territory of Puerto Rico for 4 years. That's the highest civil attorney position in their government. And then she was a judge. She was a judge until she retired for a number of years. And her husband is the alleged victim. He is a dentist here in Georgia, admitted in Georgia. They've been married 34 years. And this is an unfortunate situation where the master bedroom, after the husband came into the bedroom and went to sleep, and then the defendant came into the bedroom shortly thereafter, about 10 minutes later, they had been having an argument. Long story short, when the lights were turned on and the husband got up and they were arguing, he stepped on what is a glass jewelry box, if you can believe it, like a container for jewels and so forth, watches. And it broke. And when it broke, it was like I don't know what to analogize it to, maybe like to a tiger trap or something, or something from Vietnam. He stepped into it, and all the glass all the way around it cut into his foot. And that's what happened. She immediately tried to help him. She put towels on him and so forth. And then the EMTs and the police got there, and they quickly surmised that he would be best off going and getting some stitches. So he's all stitched up. There's no permanent injury. He's walking around like normal. And he's made it very clear to me that he loves his wife and he wants to be able to have contact with her. The situation is this: the home at the address given, the 5920 Long Island Drive, is the family home for at least 5 or 6 people. And the defendant takes care of her grandson, who's at a soccer game this afternoon. The husband has graciously, and he just came into the room, Dr. Garcia, he has a thriving dental practice, by the way, here in Atlanta. He has offered to vacate the premises if the court wants no contact, and let the wife live there with her grandchild and her daughter, and also their adult son, who is a law school graduate who's sitting for the bar exam.
Okay. Is Dr. Garcia there? Can I see Dr. Garcia? Will you please come forward very quickly?
Is it okay if the defendant gets up for
Yes, she can. Yes, for a moment. Please
Yeah.
slide over.
slide over, and then
I just have one quick question. I'm not going to require that you make a statement. Will you please raise your right hand? Do you swear or affirm testimony you give today be truth to the best of your knowledge?
Yes, I do.
All right. Do you wish to have contact with your wife?
Yes, I do.
And do you wish for her to be able to return home?
Yes, I do.
All right, that's all I really need to know. I needed to, and forgive me for asking you to come in. I did that because the state's position at this time was to have no contact, but I did want to hear from you. All right, defendant is going to receive a $4,000 signature bond at level 1 through pretrial services, broken down 3,000, count 1, 1,000, count 2. She's to have no further violent contact with the alleged victim, and she's to have no alcohol, no drugs, no weapons as a condition of that signature bond. Through pretrial services. I am going to ask that she take the 1-day anger awareness course given by pretrial. Is there anything additional from either the state or defense?
Your Honor, just in terms of logistics, where does she go to sign the paperwork, and when would she be released?
Now that I can't really speak to, but I'm sure that once the court is over and I sign the order, she'll begin getting processed out.
Okay.
All right.
Judge
So the
Williams,
faster we can get through this, the faster she gets that order to get out of jail.
Judge Williams, thank you so much, and ASG McConkey, thank you also.
All right. Does that include your business, counsel?
Yes, ma'am. Thank you.
All right. Take care. Have a good afternoon. Best of luck to all parties concerned.
God bless.
All right. Who do we have next?
Next, Your Honor, we can go to, Alberta's logged off. We could go to position number 3, Ms. Bryant.
Okay. All right. Are you Asia Bryant?
Yeah.
Aja, my apologies. Good afternoon. Your case is 25 CR001075E. In this case, you're charged with simple battery and battery. You understand your rights?
Mhm.
All right. Mr. Howard,
Can you hear me?
I can.
12 total. 2023 FTA probation. 2023 battery, felony obstruction, indicted. 2022 FTA, 2016 battery DV conviction. That's it.
Okay, thank you. Ms. Mokake, please proceed.
Yes, Your Honor. This incident happened at Emory University Hospital located at 550 Peachtree Road in Atlanta. The victims in this case are Avijah Burks and Whitney Molina. They were nurses at the hospital who were attempting to perform a medical procedure on the defendant. The defendant is accused of kicking Ms. Burks in the right shoulder and also scratching Ms. Molina on her left hand, leaving a scratch mark. The state's recommendation is a $2,000 surety bond, no further contact with the victims, stay away from that incident location except for medical necessity, of course, no drugs, weapons, or alcohol while out on bond, and that she undergo anger awareness.
Okay. I'm gonna sound for Miss Burks or Miss Molina at this time. Hearing none, Miss Bader. Good
Yes, Your
afternoon. Good
Honor.
to see you.
Good to see you too. Miss Bryant is 34 years old. As you heard, this occurred at a hospital. She was actually the patient and she was having a seizure. That's a condition that she has for which she takes medication. She does have a good address with her grandmother. The address that the court has, I believe, is correct, 560 Parkdale Drive. She's been here all her life. She has a 12-year-old son. She's went to some college at Georgia State and she works for a temp service. Judge, considering the facts of this case, we're asking for a signature bond.
Okay. All right. In light of the information before me, defendant is going to receive a $4,000 signature bond at level 1 through pretrial services per judge if necessary. $2,000 on each count. She is going to take the 1-day anger awareness course, have no contact with either of the alleged victims, and stay away from that location unless receiving medical services.
Thank you.
Is there anything additional? All right. Best of luck to you, ma'am. Who do we have next?
Next, we go to position number 11, Ms. Jackson.
All right, good afternoon, Ms. Jackson. Your case is 25 CR 001062A. You're charged with battery and cruelty to children in the third. You understand your rights?
Yes.
All right, Mr. Howard.
12, 2016 ag assault, 2 counts, conviction. 2013 simple battery, 2012 simple battery DV, obstruction of fray, conviction.
All right, thank you. Mr. Rhodes, please proceed.
Yes, Your Honor, good to see you.
Good to see you as well. Been a while.
It's been a minute. In addition to what pretrial is given, I'm showing a total of 12 cycles on the GCIC. On February 28th, 2025, Officer Kerrigan responded to 3508 Judson Avenue in East Point in Fulton County, Georgia. And it was in reference to a fight call. Upon arrival, they met with Mr. Danny Allen. Mr. Allen advised that while inside the home, his sister, LaTanya Jackson, started to attack him. He advised that Ms. Jackson attacked him in front of his daughter, actually while he was holding his daughter, whose initial. He indicated that there were, in fact, prior altercations, but this was the first time that he did, in fact, call law enforcement. When officers arrived, they did observe a red mark on his right arm from the attack, as well as a laceration on his left leg from the attack. He was able to provide video footage from the start of the incident, and officers confirmed that Ms. Jackson was the initial aggressor in this incident, and officers did arrest Ms. Jackson on the scene. As it relates to this particular case, Your Honor, we're asking that Ms. Jackson stay away from the incident location, which is 3508 Judson Avenue in East Point, Georgia, and that she has no further contact with Danny Allen or the child, whose initials are MH. I would advise that Ms. Jackson does live at the home. In addition to living at the home, she does have 3 minor children at the home as well. And so as it relates to that, we're asking that any contact that she has with the children living in the home, that there be a third party to facilitate that, Your Honor.
What is her
And
relationship
we're
to,
asking for a $3,000.
what's her relationship to
Oh, I'm sorry.
MH? Her relationship to MH is what? MH is her,
That would be her aunt.
okay,
Her aunt.
understood. All right, making sure that wasn't her child.
And the reason for the $3,000, but she does have 3 children that live inside the home, according to Mr. Allen. I would say that we're asking for a $3,000 good bond in light of her criminal history, Your Honor, the 12 cycles and the convictions that were stated by pretrial. Thank you, Your Honor.
All right, I'm sounding for Mr. Allen. Is Mr. Allen present?
Yes, ma'am. Yes,
All
ma'am.
right, if you want to make a statement, Mr. Allen, I need you to turn on your camera and raise your right hand so I can place you under oath.
Okay.
Okay, we can't see you. There you are. Miss Allen, do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, Your Honor.
All right. Um, let me give you some explanations before I let you speak, okay?
Okay.
Miss Jackson is charged with a misdemeanor offense, so she's entitled to a bond today. There will be other proceedings where she may or may not be sentenced, where your testimony about what happened will be critical. Today, that is not what's of most importance to me. What's of most importance to me is whether you wish to have contact with the with the defendant, and if you have any concerns for your safety. So with those instructions, what would you like to tell me?
Um, yeah, no, I would not like to have contact, and I fear for her. She might happen again.
Okay. Is there anything else you'd like me to know?
That's it.
All right. All right, Miss McLeod, please
Yes,
proceed.
Your
This is your
Honor.
client. Good to see you as well. Please proceed.
Good to see you too, Your Honor. I would be asking for a signature bond for my client today, and I will be explaining to the court why I think that would be appropriate. My client is 31 years old. She is the mother of 4 minor children, not 3, and they live in that house with her. She tells me that this house belongs to her father, who is currently incarcerated. She has power of attorney, and he has given her this house to stay in the house with her 4 children. She says her brother doesn't really live there, although he sometimes comes there. He actually lives with his girlfriend. So if my client is not allowed to go back to her home, there's going to be 4 minor children, the eldest of whom is only 14 years old, essentially living in that house by themselves because the alleged victim is, he's not their father. He doesn't have any responsibility towards these children. These children are my client's children. This is a sibling situation, Your Honor, not an intimate partner relationship. And my client tells me that it was her brother who started all of this. She is not currently working, so she really is not in a position to post bond. So that is why I'm asking for a signature bond for her, and that she be able to go back to this location to take care of her 4 children. My understanding is he doesn't live there, so it is easier for him to go to his girlfriend or wherever it is that he lives, and that my client be able to go back to her own home. I believe it would be unconscionable to say she cannot go home to her own home and to punish her 4 children because of this person. Nothing further, Your Honor.
All right, Miss Allen, very briefly, do you live at that address?
Ma'am.
Do you live at that 3508 Justin Avenue?
2508, and actually I do. My dad, he is incarcerated, but like he did give permission, and she knows that, for me to come over here, and but she likes to take it in her own
Well,
hands.
not come over there, but do you actually live there? That's my question.
Yes, ma'am.
Okay. All right. All right. In light of the information before me, defendant is going to receive a $1,500 surety bond, 1,000 on the battery, 500 on the cruelty. She is to have no contact whatsoever with the alleged victim in this case and stay away from that location. She can return one time with a member of law enforcement to get any of her items. Additionally, she's to have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
Yes, Your Honor. What happens to her 4 minor children?
All right. I'm sure she'll figure that out, Miss McLeod. We're not going to restrict the victim from the house in this case. All right, I'm not putting the children out of that home. Okay. Is there
Yes,
something
Your Honor,
additional?
but those are her children.
Right, I understand. I understand.
They are minors and they have nothing to do with any of this. This is between two siblings.
Okay,
And
so Ms.
based on what
McClure,
he's saying, Mr. Allen, he comes there sometimes, which is what my client tells me. Her contention, he doesn't really live there. This is their father's home, and my client is the one with the power of attorney.
okay, Ms. McLeod, I'm not gonna argue. The ruling is gonna stand. I'm sure that they will figure out some robust living situation. And it can be revisited at SAP or at a different later date. But for right now, I am gonna restrict her from that home. Okay? Ma'am, I know you have some concerns. I'm sure you disagree with what I'm saying. The best thing for you to do is give Ms. McLeod a call. I
What's
don't
the
want you to
bonnet?
make it's 1,500, 1,000 on the battery, 500 on the second count. All right?
Thank you, Your Honor. Nothing further from the state.
All right, and I'm sure Ms. McLeod has additional, and I do appreciate your zealous advocacy, but my ruling will stand at this time. All right, best of luck to you, Ms. Jackson. That concludes this case.
They told me to act, I was trying to figure out how do I get my kids from the house? Cause they're at the house by themselves right now. So how do I
But
get?
I said you can return one time with law enforcement to get your
Okay.
children or any items that you might need to get. Okay?
All right, thank you.
All right, best of luck to you. Ms. McLeod, does that conclude your business today?
No, it doesn't, Your Honor. I have other
Okay,
clients on this calendar.
okay, understood. All right, who we have next?
Your Honor, we can go to position number 23, Mr. Smith, Anson Smith.
All right, Mr. Smith, your case is 25 CR 001069F. In this case, you're charged with criminal trespass, obstruction, terroristic threats, and disorderly conduct. You understand your rights? All right, Mr. Howard, can I have the history, please?
2024 trespass, 2024 simple battery conviction, 2021 probation, 2015 ag assault, criminal damage to property conviction. That's it.
Okay. All right, thank you. Ms. Mokake?
Yes, Your Honor. I also had on his GCIC that he has a 2024 criminal trespass and willful obstruction from December. This incident happened at the European and Domestic Auto Care located at 1903 Piedmont Circle Northeast in Atlanta. Officers arrived at the location and met with 3 employees there, Jacob, Xavier, and Daniel. Jacob Avaharisa told officers that the defendant kept coming to the property and walking up and down the street, threatening to shoot him and his staff after they told him to leave. Officers did spot the defendant on the street and they drew their firearms, telling him to put his hands behind his back. The defendant refused to comply and had to be tased. While on the ground, he continued to refuse to place his hands behind his back. The state's recommendation is going to be based in part on his criminal history, which includes arrests and convictions from just last year. So we are asking for a $2,000 surety bond, a stay away from that location, no further contact with Jacob Avarisa, Xavier Mezin, and Daniel Romero. Those were the staff members that he threatened to shoot at the location. No drugs, weapons, or alcohol while out on bond.
All right, are any of the alleged victims, I did not catch his last names again, Ms. Mokake?
Jacob Avaharisia, Xavier Mezon, and Daniel Romero.
Are any of those parties on the Zoom conference in which to make a statement? Okay, hearing none, Ms. McLeod, please proceed.
Yes, Your Honor. My client is 43 years old. He tells me that he's currently disabled and he's also homeless. Of course, he does not have a firearm. So this allegation that he threatened to shoot people, I think this may just have been stated to make the situation more hyped up than it needed to be. I think they were just unhappy that my client was, obviously perhaps homeless and hanging around their business establishment. I think they may have thought that it might have driven business traffic away from where they were, so they chose to call the police on him. My client is not in a position to pay for bond, Your Honor, because as I said, he's unemployed and he's homeless. So I would ask the court to take that into consideration in setting a bond for him. He has given me an address at which he can get his mail, a good mailing address. But apart from that, he's homeless, Your Honor. So I would ask the court to give him a signature bond, even if it has to be at a higher level than normal, to allow him to get out of jail. Nothing further, Your Honor.
All right, defendant is going to receive $1,000 surety bond, $250 on each count. He's to stay away from that location and have no contact with any of the alleged victims in this case. Additionally, he's to have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing further, Your Honor.
All right, and as a reminder, his case is going to be reset to March 13th, SAP. Best of luck to you, Mr. Smith.
I haven't seen the third one.
All
Next,
right, who do we have next?
position number 27, Mr. Williams.
Can we do all of Ms. McLeod's cases first? Is that what we're doing?
Mr. Williams is one of my clients, Your Honor, I think.
All
This
right.
Mr. Williams.
All right.
Mr. Kendall Williams.
Yes. We'll try to take all your clients so you can go enjoy your weekend, Ms. McLeod. All right.
Thank you, Your Honor. Appreciate it.
All right. Mr. Williams, your case is 25 CR 001076D. In this case, you're charged with battery. Do you understand your rights? I believe that was a yes, so we'll roll with it. Mr. Howard, can I have the history, please?
31, 2025 FTA, 2024 shoplifting. He has several FTAs and theft cycles. That's all.
Any violent?
If it is, it's old.
Okay, understood. All right, Ms. Mokake.
Yes, Your Honor. This incident happened at the East Point Jail. The victim in this case is Jacoby Johnson. The defendant is accused of pushing the victim into a cell and punching him on the right side of his body, calling him a coward, and telling the victim to go tell on him. The defendant did admit to officers that he did push the victim and also did call him a coward. The state's recommendation, based on his numerous arrest cycles and the fact that he committed this assault while in jail, is a $2,000 surety bond. No further violent contact with Jacoby Johnson, as if they're in the same jail, they might, not be able to stay away from each other, but no further violent contact, no drugs, weapons, or alcohol.
Okay.
Your Honor, I would ask for signature bond for my client. He tells me that the person who, the alleged victim, was the one who started all of this. He had been antagonizing him ever since he got into the East Point jail. He had been giving him a hard time, calling him out of his name, and just being generally antagonistic. And on this particular day, he started calling him some rather unkind names, and this is what initiated all of this. As Spirituala said, my client does not have any kind of violent arrest. So obviously something happened here, Your Honor. He is not working, so he's not in a position to pay for bond. So given the fact that he has no violent history, I would ask the court to consider giving him a signature bond so he can get out of jail. He lives in Fayette County. He's given me a good address, Your Honor. Nothing further.
Okay. Ms. Mokake, do you know what the underlying charge was that had him in the East Point jail?
I'm looking that up right now, Your Honor. Let's see. Well, I'm seeing that his last arrest was a 2025 driving while license suspended or revoked and possession of cocaine. So that might possibly be why he was in jail.
All right. Defendant's going to receive $1,000 surety bond. He's to have no further contact with no further violent contact with the alleged victim. And he is to have no alcohol, drugs, or weapons. I'll reset him to SAP as well. Is there anything additional from state or defense?
No, Your Honor.
All right. Best of luck to you, Mr. Williams. Who do we have next?
Good afternoon, Judge. I do have Ms. McLeod's case over here. It's going to be position number 7, Ms. Dutton.
Okay. All right. Thank you. Ms. Dutton, your case is 25 CR 001042J. In this case, you're charged with obstruction and criminal trespass. Do you understand your rights?
Well, on the ticket, it said obstruction of an office. Judge, this is the MH.
Okay. Understood. All right. Mr. Howard.
10th arrest, 2024 FTA, 2024 fray, 2023 FTA, 2022 trespass no lows, 2020 disorderly conduct conviction.
Okay. Ms. Mokaka?
Your Honor, this incident happened at the McDonald's located at 2929 Peachtree Road in Atlanta. Officers were contacted by the manager who advised that she wanted the defendant removed from the lobby and criminally trespassed, as the manager had asked her multiple times to leave and the defendant had refused. Officers told the defendant that she was trespassed and asked for her ID numerous times. She refused to provide it, and when officers tried to detain her, she resisted by tensing up her arms and refusing to place them behind her back. The defendant and the officer both fell to the ground, where the defendant was held until backup units arrived. The state's recommendation, given her history, which does include a very recent FTA, is a $500 surety bond, stay away from that incident location, that she have no further contact with the manager at that McDonald's, Ms. Yarlin Matos, no drugs, weapons, or alcohol while out on bond, and also that she have a social worker visit.
Okay. I'm sorry, Mr. Howard, was there a criminal trespass in her history?
Yes.
What year was it?
2 no-los from 2022.
Okay, so that makes it bond restricted. Okay, Ms. McLeod, please proceed.
Your Honor, my client is unemployed right now, she tells me. So, of course, she's not in a position to pay for bond. This is what she tells me. It seems like there's some misunderstanding between herself and the manager of the McDonald's where she went to buy something to eat, Your Honor. I think based on the nature of what happened, that she really, I don't even understand why she was arrested based on what she tells me. She was a patron there. She had money to buy her food, and she was there to buy food. I know that she may have had some issues, but that may have caused the miscommunication between herself and the manager as to what was really going on, and for them to call the police on her. People don't expect to be arrested when they're out buying food from a fast food restaurant, and this is what happened to my client. She is the mother of 2 children, she tells me. She has had some college. She's an intelligent woman. She was able to articulate to me what happened between herself and the manager. And she was quite surprised that she was arrested based on what she said and did. Of course, if she doesn't get a signature bond, Your Honor, she's just going to sit in jail because she has told me she has no one to bond her out and she has no money. So just based on that, I would ask the court to definitely consider a signature bond for her. Nothing further, Your Honor.
All right, defendant's gonna receive a $10 cash bond, $5 on each count. She's stay away from that location and have no alcohol, no drugs, no weapons. Because it's a cash bond, she will go to SAP. Is there anything additional?
Nothing further, Your Honor.
All right. Best of luck to you, Ms. Dutton. That concludes your case.
Yeah, and that concludes my business before the court today, Your Honor. May I be excused?
You may take care. Enjoy this beautiful day, Ms. McLeod. See you soon.
Thank you. You too, Your Honor.
Okay, bye-bye.
Judge, I'm sorry, you said this was a $10 cash bond?
Yes, she has 2 counts, $5 each count.
Okay, thank you.
Is an interpreter going to be brought today? Was that? And Ms. Kim, will you need to use the interpreter to interview your client, or have you already interviewed the client and they just want the interpreter? Okay, understood. Understood. Will we have an interpreter today, Mr. Jordan?
I didn't request anyone, Your Honor. I mean, I can try to call. But
Will you see if we can? It may not be possible. We can try. All right.
Your Honor, this is position number 2, Mr. Brown.
Hey, how you doing today, Your Honor?
I'm well. Hold on, Mr. Brown. All right. Mr. Brown, let me read you your rights in your case. Your case is 25 CR 001055F. In this case, you're charged with terroristic threats and acts with the offense date of yesterday. You understand your rights?
Allegedly, Your Honor, I am.
And Judge, I just wanted to clarify something. I did interview Mr. Brown, but he did indicate to me,
he wants to represent himself.
Correct.
Mr. Brown, it is my strong advice to you that you allow Ms. Bader, who is very smart and experienced, to represent you at this hearing. This is what she does all the time. Of course, it is your constitutional right to represent yourself, but I think you will be at a disadvantage if you choose to do so. Are you indicating today that you are declining the services of the public defender's office?
I'm not, ma'am. I just would like the right to have competent representation instead of.
She is very competent. I can guarantee you that, Mr. Brown.
can't seem to come to a mutual agreement, so I have to take that.
And she's not competent.
So, I would like to choose to go forward and represent myself, Your Honor.
Okay, well, I don't think that's a great choice, but of course, again, it's your right. We'll move forward. All right, Mr. Howard, can I have that history, please?
15. Open false statements or writings, uh, conceal facts or fraudulent documents, tampering with evidence. That's 25 PI 000121. Got to open theft by receiving DUI. Open alcohol out of Superior Court. It's 24 SC 25 SC 000062. Open fleeing, attempt to elude, reckless driving, driving without a valid license, DUI. It's 24 CR 000002F. Got to open obstruction and disorderly conduct out of Baldwin County. 2024 FTA, 2017 FTA, 2015 cruelty in the first offender.
Okay.
Yes, Your Honor.
All right, now hold 1 second. We'll let you speak, okay? Mr. Rhodes, please proceed.
Yes, Your Honor. As it relates to Mr. Brown, the allegations are on February 28th of 2025, Officer Smith arrived at 2655 Donald Lee Hollowell Parkway in response to a dispute. Upon arrival, he spoke with two victims. One was Mr. John O. and the other was Miss Naomi Foster. He asked Ms. Foster what happened, and Ms. Foster stated that a male later identified as Mr. DeMario Brown had come into the store threatening patrons and staff. Ms. Foster stated that Mr. Brown had told herself, the rest of the staff and patrons, that he was going to come back to the store and shoot the location up after being asked to leave the location. Ms. Foster stated that Mr. Brown told her that he was going to have his sister personally come and attack her for asking him to leave. Ms. Foster also stated that Mr. Brown told a Hispanic female employee that he was going to call immigration ICE on them and have them deported. Mr. Foster stated that Mr. Brown finally left the location, but not before trying to fight an Hispanic male at the location. In addition to what pretrial has provided, Mr. Howard, I'm showing a total of 15 cycles on his GCIC. And so as such, we're asking for a $3,500 good bond, a stay away from 2655 Donald Lee Hollowell Parkway in Atlanta, Georgia. And I have no contact with Mr. John O. or Miss Naomi Foster. Thank you.
All right, I see Mr. O is on the line. Mr. O, you're not required to make a statement, but if you wish to do so, please turn your camera on and raise your right hand.
My accuser.
All right, do you swear or affirm the testimony you give today, Mr. O, will be the truth to the best of your knowledge and given under the penalty of perjury?
Yes, I do, Your Honor.
All right, again, you may have heard me give these instructions earlier, and I'm going to give them the same to you. This is a misdemeanor offense, and as such, Mr. Brown today is entitled to a bond of some type. There will be other proceedings at which your testimony regarding the facts are critically important. Today, that's not of the most critical importance, and I'm sure that this charge is a little bit different, so I'm hearing from you kind of as a courtesy. But in light of those instructions, what I'm most concerned for are any concerns you have for your safety. What would you like to tell me, Mr. O?
So this is actually not the first time that something like this has happened. Back in October, some very similar incident. He came in the store and he was basically came in at 2 p.m. and up to 10 p.m. he threatened us, threatened employees, threatened to wait for us to close, and physically assault us. I just want him to not be able to come back to our location.
All right. I appreciate you coming to court and making that statement, Mr. O. Okay.
Absolutely, Your Honor. Thank you.
All right. Take care. All right, Mr. Brown. Again, you still are declining the services of Ms. Bader and wish to represent yourself. Now, understand, Mr. Rhodes is a prosecutor, and he's here, and everything you say, he's going to have the right to use against you at trial. So whatever you're about to tell me, the state is listening very closely, and you may think you're saying something to help you. You may be saying things that are actually hurting your case. If I feel that your testimony is starting to go off the rail, I will stop, because today the only issue that I'm considering is a bond. All right. So if you would like to tell me about your ties to the Atlanta community, your employment, or things of that nature, that would be appropriate. If you wish to dispute what happened or what Mr. Rhodes said today, I don't think that's wise. Again, I strongly advise you to take the services of the public defender's office. What would you like to tell me, Mr. Brown?
You stated, you would like for me to explain you what my role was to the Atlanta community. I'm a native Georgia, from the state of Georgia, North Georgia, and the city of Atlanta. As recently earlier was stated that I had a case involved that I represented myself and got this case dismissed it in a 2-year period of time. This case will be dismissed on a 2-year ban of me self-representing myself and other things as more other cases allegedly. In the future will show you that I have the reasonable the prove beyond a reasonable doubt and beat the burden of proof that I'm an innocent man. You know, these just are all allegations being tossed around, witch hunts, being a bunch of women, witch hunts that shouldn't be in play and, shouldn't, a lot small things, and I just ask that, you know, and may the same God who choose to testify, may you give a court order that he stay away from me as well.
All right.
I need a court order, and I would ask I would like to know what is the consideration of my bond.
All right. Based upon the information before me, defendant's going to receive $1,000 surety bond. He is absolutely not to return to that location on Donnelly Hollowell Parkway and have no contact with any of the alleged victims in this case. Additionally, he needs to have no alcohol, no drugs, no weapons, and he is going to the all-purpose calendar on the 13th, whereby aspects of this case can be revisited if necessary. All right, Mr. Brown, I appreciate your demeanor today, and best of luck to you. All right, this case is now, well, this matter at this time is now concluded.
Okay, and maybe we just go ahead and just dismiss this case. It's like,
No, that won't. This is just your bond hearing. We won't be dismissing anything today. All right.
what do I have next for here? My next hearing.
Your next hearing, well, if you don't make bond, your next hearing will be the 13th of this in fact this month. Okay.
How much is my bond? I don't understand how much.
It's you have $1,000 surety bond. You can go through it. You should really have employed the services of Miss Bader, who would have explained all of this to you. You have $1,000 surety bond. You can go through a bonding company whereby you only have to pay a portion of that. Okay.
I mean, right now the peace officers cussing me out, man. We gonna have a mistrial. It's lead to a mistrial, man. Right now we already getting mistrial phases. If the peace.
Okay. All right, Mr. Brown, best of luck to you. We've resolved the matter for now, okay? And it's my strong advice that if you don't want Miss Bader, you get another attorney. Take care.
I got it, man. Thank you, man.
All right. Have a good afternoon.
Your Honor, if we could go to Alpharetta Jail.
Okay. Who's at Alpharetta Jail?
This is Miss Salcido Rebecca.
What number?
21.
Position 21.
21.
Okay. Thank you. I'm sorry. I was looking for Delgado, which should have been closer to the top of. Okay, Delgado. My apologies. All right. Miss Delgado, did you hear your rights today? You can just nod. All right, your case is 25 CR 001077A. In this case, you're charged with obstruction, failure to have your license on your person, a brake light violation, failure to have your decal and your tag, and illegal stop or park were prohibited. And you did you understand your rights today? Even though you said you heard them, you understand. All right, thank you, Mr. Howard.
I don't have that one.
All right, we'll defer to the state, Ms. Mokake.
I have that this is her first arrest. There was no record.
Okay, thank you. Please proceed.
This incident happened on the 28th. Officers noted that the defendant's vehicle was in the center lane. The door was open and she was leaning out of the car. The officer did turn around to go see if the defendant was okay, but she had gotten back into the car at that point and was driving away. The officer noted that her registration decal was from July of 2024 and began to initiate a traffic stop where he noticed that her third brake light on the top of her rear hatch was not working. The defendant told the officer that she didn't have her driver's license on her person And when the officer asked for her name and birth date, she refused to provide it, stating that she was not required to give it to the officer. After asking for her information about 4 times, she was told that if she didn't open the door and step out of the vehicle, officers would have to open the door for her and drag her out. She still refused, and she was subsequently pulled out of the vehicle and placed under arrest. Given that this is her first arrest cycle, the state's recommendation is for a signature bond and no drugs, weapons, or alcohol while out on bond.
Hey, I got a question. What's the defendant's middle name?
Do we know?
Is it on the booking?
Let me see.
You think it might be an identity issue, Mr. Howard?
I went to the file they uploaded. I got a 2023 DUI out of Gwinnett with no disposition. That's all.
Okay.
I have it's Christina
Okay,
on
yeah.
the citation.
So yeah, this is a second arrest then. That's a 2023 DUI out of Gwinnett.
Does that change the state's recommendation, Ms. Mokake?
2023 DUI, and it was just an arrest, not a conviction.
That's what it shows, correct.
Okay, I'll still request a signature bond, Your Honor.
Okay, and you understand obstruction is still bail restricted, but we will deal with that. Ms. Kim?
Through pretrial,
Yes.
or is it still restricted through pretrial?
Yeah, well, we'll work that out, but I just want to make sure your recommendation remains the same. Ms. Kim, any objections or any
Objection.
thoughts?
No.
All right, I'm gonna do something different with the obstruction, and you can let me know if you have a specific objection to this. As it stands, the defendant will receive a $4,005 signature bond, split bond. My intent is to give her a $5 cash bond on the obstruction and $4,000 in signature bond through the jail, with the requirement that she have no alcohol, drugs, no weapons. She would essentially get reset to SAP, but I believe that she might be able to find somebody with the $5 to get her out of jail rather than having to go through pretrial. Any objection to that, Ms. Kim?
Can I talk to my client if that's okay with her? Because I just
Okay.
want to hear. Can you tell me if it's okay?
Okay.
I
Do you
think
have
it's
somebody?
okay with her. She seems to be okay with it.
Okay, you have somebody who can give you $5. Okay, because I
Yes.
think that's better than burdening pretrial with
Yes.
this.
Yes.
All right. So that will be the recommendation in the ruling, $4,005 split bond through through the jail and then cash and the no alcohol, drugs, weapons. Anything further from state or defense?
Nothing from defense, Your Honor.
Uh-oh, Mr. Jordan's gonna yell at me. Yes.
No, I was gonna ask, is that 1,000 for charge?
1,000 on each count through the jail.
Okay, thank you.
And $3,005.
She just got to make $5 bond in cash. All right. Best of luck to you, ma'am. That concludes your case. Is that complete? Are we completed, Alpharetta?
Rhonda, can you repeat that breakdown?
It's 1,000 on each count except for the obstruction, and there's a $5 cash on the obstruction.
Listen to me, please.
I just have to say one thing for the record. Breaking the window was a little too excessive for the traffic charges. I just want to have to say that. That's all.
I'm sorry, Ms. Kim. What do you mean breaking the window?
Officers broke her window, Your Honor.
Oh, okay. Well, I'm sure that will come out at a later date. All right. Best of luck to you, ma'am. Again, is Alpharetta complete?
Yeah, that's it, Your Honor.
All right. Take care. Have a good afternoon. Good Saturday. Bye-bye.
Thank you.
All right. Who do we have next?
Judge, before I go ahead and proceed, I do have a quick announcement for position number 10, Ms. Hop. Her bond is actually paid for.
Okay, so she's bonded out. Oh yeah, we've got that one. 10 bonded out.
Okay.
Thank you.
You're welcome. Next is position number 4, Ms. Burney.
All right. All right, Ms. Burney, your case is 25 CR 001056D. In this case, you're charged with simple assault and criminal trespass and damage. You understand your rights? Was that a yes? All right, Mr. Howard.
Fifth arrest, 2024 FTA, 2021 disorderly conduct, obstruction, no law, and she has a fugitive from justice hold.
Who, from where? You know?
I forgot. I didn't make note of it.
Okay, that's fine. All right, Mr. Rose, please proceed.
Yes, Your Honor, as it relates to Ms. Burney, the allegations that are on February 28th of this year, Officer Tingy was dispatched to the 3200 Stone Road, Southwest Atlanta, Georgia address. Upon arrival, they met with the victim, who is Mr. Jamario Taylor. He was holding the accused to prevent her from breaking things in the house. He indicated that the side window of the apartment was broken by the defendant. The victim stated that the accused lived at the location. They were in fact dating since December of 2024. However, the accused had been gone for a couple of weeks, and I believe 4 weeks, and came back late at night and began to bang and kick at the door and break things. And as such, the defendant was arrested. The victim we've been in contact with, do believe he's on the call. He's indicated that what the officers wrote in the police was not completely factual, that she did not break the window. He does want to have contact with her. We believe that the facts are what they are. They are on body cam, Your Honor. So we're asking for a $2,000 signature bond level 2. And given she does have from my look at the GCIC, she had previous allegations of and convictions of violence and willful obstruction of law enforcement officer. So we ask that she perhaps take a one-day anger management course, along with a $2,000 signature bond level 2, if you feel like that's appropriate. Not necessarily stay away from 3200, because he does want contact with her. No further violent contact with Jamario Taylor, and he is on the call. Thank you, Your Honor.
All right, I'm gonna sound for him in a moment, but Ms. Bader, you have objections to that recommendation?
To the signature bond, Your Honor?
And no further violent contact?
No objection to that.
All right, Mr. Taylor, if you wish to make a statement very briefly, please raise your right hand. Do you swear or affirm the testimony you give today be true to the best of your knowledge?
Yes, ma'am.
All right, let me explain something. The state and defense essentially agreed that your girlfriend should be allowed to return home and have contact with you. You have any objections to that?
No, ma'am.
All right, and then other than that, like I said, the facts, and if you disagree, that's not what's of critical importance. I'm most concerned with concerns for your safety. Is there anything else you would like to add about contact or safety? But as it all stands, we're agreeing that she's going to be allowed to come home.
Yeah, if she wanna come home, she can come home. I'm not. I ain't sure.
All right. Is there anything else you want me to know very briefly?
No, I was just gonna make sure I made the meeting.
Okay, very good. All right, at this time, defendant is going to receive a $4,000 signature bond through pretrial services at level 2, $3,000 on count 1, $1,000 on count 2. She's to have no further violent contact with the alleged victim. She's going to take the one-day anger awareness course and have no alcohol, no drugs, no weapons. Is there anything additional from state or defense?
Hey, this would be per judge. She got a fugitive warrant, so
Yeah, okay, per
I don't
judge.
know where she going and how long she gonna be gone.
That's why I was trying to ask where it was from.
I'm not sure. It's on the booking and it.
Okay. Well, hopefully she'll deal with that when she has to check in with you all or before.
Nah, she gonna go there when she get out of court.
Oh, that's true. That's very true. Are you aware of that, Miss Bader? I guess so.
Yes, I'm aware, Judge. It's my understanding that it's from Florida and that it was actually dismissed, but it perhaps
If Mr. Howard's still seeing it, it doesn't seem like it's this. It sounds like she's going there. Okay, well, this case won't be the issue. All right, best of luck, female. That concludes this case. Who do we have next?
Your Honor, Alpharetta has one more, but they are on their way to put him in front of the camera.
Okay, understood.
In the meantime, we can go to position number 1, Mr. Addison.
Is Mr. Addison coming? All right, good afternoon, Mr. Addison. Your case is 25 CR 001054Y. In this case, you're charged with criminal trespass and damage to property. Do you understand your rights today? All right, Mr. Howard.
39 on probation for meth out of Superior Court. Criminal attempt to commit a felony as well, and burglary first degree. 2013 criminal damage to property conviction, and a 2023 interference with government property conviction. Couple of FTAs.
Understood. Mr. Rhodes, please proceed.
Yes, Your Honor. Very briefly, Mr. Addison is a multi-state offender, and it's alleged on February 28, 2025, at approximately 9 p.m., Officer Mitchell responded to 2391 Armand Road, Northeast in Atlanta, Georgia, in reference to a male that was observed in the home, in which I believe he was observed via video surveillance, in which it was noted that the back door had its glass window broken out, where Patrick Lamont Addison was hiding in the bathroom near the sink. Mr. Addison was then ordered out of the restroom and detained. The owner of the home was the one who called and was later identified as Mr. Thomas Van Smith, and advised that he did not know Mr. Addison and that Mr. Addison did not have permission to be inside of the home. As such, Mr. Addison is charged with criminal trespass. Given the fact that he does have a lengthy criminal history and he is a multi-state offender, we are asking for a $5,000 good bond, stay away from 2391 Armand Road in Northeast Atlanta, Georgia, and have no contact whatsoever with Mr. Thomas Van Smith. Thank you, Your Honor.
Thank you. Is Mr. Smith on the line and wish to make a very brief statement? All right, hearing none. Ms. Bader?
Yes, Your Honor. Today we're going to be asking for a signature bond. Mr. Addison, essentially any bond is gonna just make him say he doesn't have any money or someone that can bond him out at this particular time. He does have contact and a good relationship with his mother who lives in South Carolina, and he also resides at a shared house in Riverdale. So he does have housing that he can go to if he is released. And I explained to him how to update his address at the courthouse, so he will be able to get notice for court. He is presumed innocent on this charge, and he does have some college, and as it relates to education, he's just in between jobs right now. So, Judge, we're asking you to consider a signature bond for this case. Thank you.
All right, defendant's gonna receive $1,000 surety bond. He's to have no contact with Mr. Smith, stay away from that location, have no alcohol, no drugs, no weapons, and he is going to the SAP calendar whereby this bond can be revisited. All right, best of luck to you, Mr. Addison. What do we have next?
Your Honor, can you repeat that bond amount?
1,000.
Can we go, you can go to position number 5, Mr. Calloway.
All right, Mr. Calloway, your case is 25 CR 001057Y. In this case, you're charged with criminal trespass. You understand your rights?
When you say right,
You have a right to remain silent. You have a right to an attorney. I'm conducting this hearing by video. You understand all of that? All right, we're gonna
You
assume
got 123rd.
123.
Yeah. This is 123rd arrest. 2025 obstruction trespass. I'll just leave it there.
Okay, I think we understand. Mr. Rhodes? You're muted, Mr. Rhodes.
Thank you, Your Honor. Very briefly, as it relates to Mr. Calloway, on February 28, 2025, Officer Lee responded to the 24-hour food mart on Cleveland Avenue, and he saw two males arguing. One was the defendant, Mr. Calloway, and then the other one was the store clerk. The store clerk advised that he caught Mr. Calloway stealing 2 bags of chips, and that he was trespassing pursuant to a incident case number where he was advised not to come back on the premises. And the clerk was able to provide an incident case number to the officer of the criminal trespass from the previous incident. Mr. Calloway was issued criminal trespass warning by Officer Brown, another officer. The clerk also provided with multiple case numbers where Mr. Calloway has continuously come into the store to steal, And in this particular incident, he provided surveillance camera of the theft. The officer was able to see the theft on the camera. When the clerk stopped him, he was scratched during the process, but said he didn't want to press charges as it relates to that. You heard the amount of arrests. Obviously, there may be some other things going on, Your Honor. We're just asking for a $1,500 good bond. Stay away from 5 Cleveland Avenue, Southeast Atlanta, Georgia. No further contact with the clerk, Mr. Rafiq Jabrini. And Rafiq is spelled Rafiq, Jabrini, Jabrani. Thank
All
you.
right. Is that gentleman on the line, Rafiq Jabrini?
I don't believe so, Your
I
Honor.
don't think so. Ms. Bader, please proceed.
Yes, Your Honor. Mr. Calloway is 54 years old. He has been living at the same address since he was 4 years old. He's been living in this home for about 50 years. It's his family home. It belonged to his parents, and they passed away. He lives there with his siblings and his 4 grandchildren that he helps take care of. This store is in that neighborhood that he's been living in for all these years. And it seems like there is conflict with this clerk. I spoke to him at length about just staying away from this particular store. But Judge, the allegations are for attempting to steal 2 bags of chips. So I really don't think this is something he needs to be in until March 13th for. I will also add that he was in the Navy for 2 years, and he, for work, does construction and lawn care. And like I said, takes care of his grandchildren with the rest of his siblings. Pretty tight family unit that have been living at this house for his whole life. So, Judge, I would ask, and I believe, I could be mistaken, I believe the bond is currently at $600, but as I stated, we're asking for a signature bond. We're fine, of course, with the stay away that might already be in place, and just, I guess, emphasizing to him to not return to this store. But I do believe that a signature bond is appropriate here.
All right, defendant's going to receive $1,000 surety bond. He is to stay away from that location. Have no contact with Mr. Jabrini. Have no alcohol, no drugs, no weapons. Is there anything additional?
None from the state, Your Honor.
Nothing further.
All right. Best of luck to you, sir. Who do we have next?
Position number 8, Mr. Harper.
Thank you, ma'am. Thank you, Miss.
All right. All right, Mr. Harper, your case is 25 CR 001059Y. In this case, you're charged with simple battery. Do you understand your right? Oh, he's not there.
He's coming up, Your Honor.
All right. Do you understand your rights?
Yeah, ma'am.
All right.
Third arrest, 2022, possession of a Schedule 2, sale of marijuana, and 2015, possession of marijuana.
Okay. Mr. Rhodes, please proceed.
Yes, Your Honor. As it relates to Mr. Harper, the allegations are that on officers arrived to 150 Ontario Drive, Atlanta, Georgia, and they met with a Shantrevia Todd. Shantrevia is spelled Shuntrevia. Todd is spelled the traditional way, who stated that Mr. Quentin Harper had grabbed her by the neck and threw her to the side. Ms. Todd noted that she and Mr. Harper had been living together for 2 months. They have been in a relationship for 10 years, but only living together for 2 months. And she stated that Mr. Harper, she wanted him to leave the home, but he refused to do so. We have been in contact with Ms. Todd. She indicates that what's in the warrant is in fact factual. She indicates that she believes that Mr. Harper does need help, that he may be suffering from drug and alcohol abuse. Be that as it may, Your Honor, we're asking for a $2,000 signature bond through pretrial services. Stay away from 150 Ontario Drive in Atlanta, Georgia. and to have no further contact with Shantrivia Todd. And please let me know if you got the spelling or not. I can
I see her on
attempt to
here, so I've
respell it.
got it. So you said the state's position is no further contact at all, and a
Yeah.
signature line. Okay.
Yes, Your Honor.
All right, Ms. Todd, I see you on the Zoom conference. If you wish to make a statement, this is your opportunity. You do not have to, but if you wish to, this is your chance. Please turn on your camera and raise your right hand if you wish to make a statement. All right, please raise. Are you driving? All right. Are
No,
you?
I'm not driving, but
Are
I
you
don't
in
have
a
a statement.
car? Oh,
I
you
mean,
don't wish to make a statement? Okay, understood. All right, Ms. Bader, please proceed.
Your Honor, we don't have an objection to the signature bond and the stay away, and the no contact. I asked him these questions, and his mom lives in Riverdale and he can live with her.
Okay. All right, so defendant will receive a $4,000 signature bond through pretrial services. He is to have no further contact with the alleged victim, Ms. Todd, and stay away from that location. He's to have no alcohol, drugs, weapons, and he's going to take the 1-day anger awareness course. Is there anything additional?
Nothing from the state, Your Honor.
Nothing further, Judge.
Uh-oh, Mr. Jordan's going to get me.
Oh, no, I missed the bond.
What, 4,000,
4,000?
pretrial level 1. All right, sir, if you have, I'm giving you a signature bond, I'm letting you out. Do you have a more specific question?
I'm just trying to wonder what I need to do to get all my stuff.
Okay, he can return one time with a member of law enforcement to get any items. Apologies for that. All right? Best of luck to you, sir.
Next, we can go to position number 12, Mr. Jones.
All right, good afternoon, Mr. Jones. Your case is 25 CR 001063F. Your child your false report of a crime. Do you understand your rights?
Yeah.
All right, Mr. Howard.
This is second open case, crossing state county guard lines with drugs or weapons without consent. Use unmanned aircraft system to obtain or possess prohibited items. Selling marijuana and drug trafficking.
Okay. All right, thank you, Mr. Rhodes.
Sean, one moment. I seem
No
to
problem.
erase my notes here. Now, please bear with me. I seem to accidentally erase notes on this particular case, but it appears that after receiving information, Detective Manson checked with South Fulton Police Department reporting system about a vehicle that had been stolen. On August 27, 2023, Raphael Jones contacted the city of South Fulton Police Department at approximately 12:37 p.m. and he reported that his rental vehicle was stolen, which was a gray 2021 Nissan Rogue. He indicated that he arrived at the Ace of Spades Club located at 304 Fulton Industrial Boulevard in the city of South Fulton, and that the vehicle was parked. And while he was in the club, and when he came out, the vehicle was then missing. On August 30th, 3 days later, Detective Manson contacted Mr. Jones to inform him that the vehicle was in fact recovered. And to clarify what time he arrived at the Ace of Spades Club, Jones advised to Detective Manson that he arrived at the club between 10 p.m. and 11 p.m. Jones advised that he had already spoken with the detective, who disclosed that the vehicle was found in Montezuma, Georgia. Jones advised that he did not know where that place was located. Detective Manson then thanked Jones for speaking with him regarding that information. Due to the flock license plate camera reading system that captured the Nissan Rogue license plate number on Fulton Industrial Boulevard during the time Jones allegedly arrived at the Ace of Clubs Spades Club, detectives strongly suspected that Jones fabricated and falsely reported the vehicle as a stolen vehicle. Detectives suspected that Jones himself drove the vehicle to the area near Stagecoach Road, and South Fulton Police Department detective suspicions was confirmed on October 25th, 2023, when they received a phone call from a Detective Pierce advising that he had received Raphael Jones' phone records and that the records showed Jones in that area, the Stagecoach Road area, on the date of the actual collision. The phone records provided additional proof that Jones falsely reported the Nissan Rogue stolen. As such, officers charged him with false report of a crime. Your Honor, in light of his criminal history, we are asking for a $3,000 good bond. Thank you.
All right, Ms. Bader.
Judge, this warrant is from August 27th, 2023. I'm not really sure why it was taken out. There's not really a lot of facts to support this claim. Mr. Jones has a good address. The address on file is correct. He has ties to the community. He's lived in Georgia for 5 years, but also his cousins, his uncle and his brother and his sister-in-law all live in DeKalb County as well. He is gainfully employed. He's also a graduate of Northern Illinois University with a bachelor's degree in sociology and a minor in criminology. And he's currently working on getting his master's in cybersecurity at Kennesaw State University. And we're asking for a signature bond for the reasons I stated, Judge.
All right, defendant's gonna receive $1,000 surety bond. I don't think any other conditions are necessary except no alcohol, drugs, or weapons. And he's gonna be reset to SAP. I'm sorry, was there other conditions requested, Mr. Rose?
There were not. I just failed to mention, and I don't know if pretrial did. The subject was picked up on from Wilcox County Jail on February 28th, 2025 for trafficking cocaine and other drug-related charges. But other than that, I don't think that'll change the recommendation, Your Honor.
Right, I don't think so either. Okay, so $1,000 surety bond, no alcohol, drugs, weapons, going to SAP. Best of luck to you, Mr. Jones.
Your Honor, Alfred is ready with position number 17, Mr. Mosley.
Okay. All right. All right, good afternoon, Mr. Mosley. Your case is 25 CR 001079F. In this case, you're charged with obstruction. Do you understand your rights today?
What number is this?
17.
He was a bind over.
Oh, I don't think you heard your rights. Mr. Mosley, let me apprise you of your rights. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today. And as you can see, I'm conducting this hearing by video. That means I'm not there with you, and any member of the public can watch this. Do you understand your rights and how I'm holding the hearing today?
Can I get time, sir?
Okay, I think you understand, so we'll forge ahead. Mr. Howard?
I'll do the history, Your Honor. It's a bind over. I'm not sure if
Okay,
Mr.
he may not have it. Okay, Ms. Mokake, please proceed.
This incident happened at Tapper's Tavern, located at 33 Main Street in Alpharetta. The defendant is accused of refusing to listen to officers' commands to stay seated after they explained that he was criminally trespassed from the location. He kept trying to get back into the location. I do see that he has 9 arrest cycles in Georgia, including a 2024 criminal trespass, another 2024 criminal trespass that he pled nolo to, a 2023 criminal trespass, and some older criminal trespasses and DUIs. He also has 8 arrest cycles out of Tennessee. They're all from around 2006. They're mostly intoxication. There's also an arrest for theft and littering. The state's recommendation, given his recent convictions, is a $500 surety bond, a stay away from that incident location, 33 Main Street in Alpharetta. No drugs, weapons, or alcohol, and a social worker visit may be beneficial for Mr. Mosley.
I'm sorry, and the recommendation for bond again, Ms. Mokake, I missed it. I was
Sorry,
looking up
it was a $500 surety.
500 surety. Okay. Ms. Kim?
Your Honor, this is bind over and the bond order from Alpharetta case bind over, it clearly says that bond amount is 0.
Oh, does it?
Yes, and so he has been in the jail from ever since February 18, 2025. For last 10 days, he has been incarcerated for this one charge. I was wondering if he can get a signature on bond to be released through jail. He was born and raised here in Georgia. He graduated from Roswell High School, 1998. He does not have any drug or alcohol issues. He does have a brother here in locally. I think he needs to get out, be released without any
If it was a 0 bond, what happened? Does
I
anyone
don't
know?
know. That's why I was kind of confused about this. It says clearly right here. I don't know if you can see it. It says
I
a 0.
can't see.
Yeah.
If
I
it's
can
a
email
Odyssey
it.
has it. Sorry, PD Kim. Our Odyssey just has it as hold without bond. So I'm trying to see if maybe
hold without bond is very different from 0 bond. So let's
I see 0 bond right clearly here on the paperwork that was signed on February 22nd by judge, and then solicitor's election to bind over to solicitor's approval. But Your Honor, it says there's another one, bond reduced to 0.
Okay, I do see
February 21 jail case.
Mr. Jordan seems like he's here. What do you know what happened, Mr. Jordan?
So they put 0 bond on the bond order. So the jail put it as a no bond hold on the jail screen. So he's not being released without a bond.
Can we do? I mean, that doesn't make any
So
sense.
it doesn't say signature bond on the bond order. It just says 0 bond, meaning they gave him no bond on the charge at all. I don't know
So he got no bond. And so has he truly been incarcerated on this one charge since the 18th?
Yes, yes. And Your Honor, it doesn't make any sense not to have any bond if it is no bond. This is misdemeanor, Your Honor. He's entitled to get a bond. So not having any bond does not make any sense.
No, I agree with that. I'm just trying to figure out what happened. There's a
So the jail screen is saying that he's been in, I guess, this jail since the 28th. But that doesn't necessarily mean, like Ms. Kim said, that he wasn't held somewhere else.
Okay. I'm trying to decide if it's Riverside or not. And I'm not, that part is unclear. To me, his obstruction, that what flies in the face of Riverside here is that obstruction is a bail restricted offense. So technically he can't get a signature bond through the jail. It would have to go through pretrial, which again is not ideal. But if it is a Riverside issue, I don't know if that overcomes our new bail restriction or not.
I believe this is a Riverside issue, Your Honor. He's been in the jail for 10 days.
The safest thing for me to do is send it through pretrial to make sure I don't, unfortunately. Okay, so defendant is going to receive $1,000 signature bond through pretrial services at level 1. He's to have no alcohol, drugs, weapons as a condition.
Thank you, Your Honor.
All right. All right. Best of luck to you, Mr. Mosley.
Does he have an address? This will be per judge. Don't worry about it.
Yep, I do have an address. I can text to you or email you.
Don't worry about it. We can go
All
next.
right. All right.
Thank you.
Next is condition
you-
number 15, Mr. Lilly.
I'm sorry, Mr. Jordan.
No, I was going to ask, did you want the stay away condition on the bond order?
Technically, I think I can't. Well,
Okay.
because if it's Riverside, even still sending it through pretrial is questionable. So no conditions. All right. Who do we have next?
District 15, Mr. Lilly.
This is Stephen Lilly.
Yes, Your Honor.
All right, making sure. Sir, your case is 25 CR 001078C. You're charged with DUI and possession of open container. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Yeah, you got 18. 2023 DUI suspended license arrest. 2019 driving without a valid license, no-low. 2015 DUI conviction. Another 2015 DUI arrest. 2014 FTA. 2011 DUI no-low. 08 DUI conviction.
Okay. Mr. Rhodes, please proceed.
Yes, Your Honor, on February 28th of this year, Investigator Smith was on a routine patrol and observed a black Hyundai Genesis with a license that was affixed to it in the rear of the vehicle, parked in a turning lane on George Washington Carver High School in McDonough Boulevard Southeast. He immediately pulled behind the vehicle and activated emergency lights. Once he exited his vehicle and approached the driver's side of the vehicle, he observed that the driver, who was later identified as Mr. Stephen Lilly, was asleep in the driver's seat. He then woke Mr. Lilly up and began speaking with him. He immediately, upon speaking, observed a strong odor of alcoholic beverage emanating from Mr. Lilly's breath. Mr. Lilly was slurring his words and seemed disoriented. He asked Mr. Lilly if he had any alcohol to drink, which he advised he did not. He observed a brown paper sack in the passenger seat, which is commonly used to contain alcoholic beverage. He asked Mr. Lilly if he would step outside the vehicle. Mr. Lilly protested and asked him if he was taking him to jail, then asked Mr. Lilly again to step out of the vehicle so he could conduct a field sobriety evaluation. Mr. Lilly refused the field sobriety evaluation. Inside of the small brown paper sack was a bottle of 200 milligrams of Hennessy, which was halfway empty. Your Honor, as already indicated, there's a total of 18 to 19 cycles on his GCIC. A great deal of them including DUIs previously. And there was a 2010 DUI arrest. In 2011, he pled no-low to DUI. There was a 2015, August 26, 2015 arrest, but there was also a 2015 guilty DUI conviction out of DeKalb County and that incident date was October 24th, 2015. And there's also a 2023 Clayton County DUI arrest. Given the amount of
Quite a few DUIs. Okay,
Yes.
keep going.
Yes, Your
All
Honor. Given the amount of DUIs and convictions that Mr. Lilly has received, we believe he is reaching towards, if it's not already a habitual violator. As such, we're going to be asking for a $12,000 good bond, alcohol drug evaluation and treatment, and that he had no alcohol, drugs or weapons on him while out on bond, or weapons, Your Honor. And so that is the state's recommendation. Thank you.
Okay, that is quite a history, Ms. Kim. But
Well,
okay, please proceed.
Yes, pretrial reports was recommending for pretrial service number 2, level 2, not even 3.
That was a
So,
discrepancy, Kim. Sorry about that.
but anyway, I would like to request for still a maximum $1,000 good bond. He does have a good job right now. He also has a 3 years of college education from Georgia Southern University. He's been here in Georgia for the last 30 years. He's not a flight risk. And Your Honor, the point is he was not actually driving at that time. So technically, I don't think that he was DUI driving because he was not driving. He was sleeping in a car. So that's the argument I would like to for a signature on bond through pretrial level 3 if possible, or maximum $1,000 good bond.
Ms. Kim, I appreciate your advocacy, but this is one of the worst DUI histories I've heard in a long time. Defendant is going to receive $1,000 cash bond, 500 on each count. He is not to drive whatsoever. I'm not going to do the AEDET at this juncture, but I'm sure that's something that will be considered. I would like this case to be referred to DUI court if possible. So within 3 days, Ms. Kim, if you could see if that referral can be made so
Sure.
that we can see if there are other additional help that we can provide to this defendant.
Sure.
And he's have no alcohol, drugs, or weapons. He will be reset SAP 313. And again, I'm asking that it be referred to DUI court if possible.
Thank
All
you.
right, Mr. Lee, best of luck to you. Take care.
Next, we go into position number 16, Mr. Menace.
All right, Mr. Minish, your case is 25 CR 001064J. You're charged with theft by taking and simple battery family violence. Do you understand your rights? All right, Mr. Howard.
Fifth arrest on probation out of Jackson County, possession of meth, 2 counts of possession of a controlled substance, Schedule 2. What else? 2019, no, that's the meth. 2016 simple battery DV convictions. And the 2020 trespass conviction, I'm sorry.
2020 trespass, okay. All right, Ms. Mokake?
Yes, Your Honor. I have that this incident happened on the 25th at 1310 Hampton Drive in Sandy Springs. The victim in this case is Janina Linares, who is the defendant's wife. The defendant is accused of being intoxicated and hitting his wife in the back of her arm and right side of her face. The defendant then took her phone and proceeded to leave the location with alcohol and a change of clothes as a friend of him had come to pick him up. Before leaving, he did turn off the Wi-Fi to the house, and the victim had to go to her neighbor's house to call 911. The state's recommendation, given the alleged facts in this case and his history, which does include a family violence conviction, is a $2,000 surety bond, that he have no further contact with the victim at this time, that he stay away from the incident location, and have no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim. Our office has not had a chance to speak with her yet.
All right, and I'm sounding for Ms. Minares at this time. I don't see anyone with that name. Okay, Ms. Kim?
Yes, Your Honor. He was born and raised here in Georgia, Your Honor. I think his wife and my client are going through divorce. So there is a little bit of, he denies the allegation and telling me that maybe there was a vindictive motivation to come up with this allegation that he didn't even take the phone, Your Honor. So it was. He does have a good job right now. He also has a bachelor's degree from ASU. He does not have any child, so there's no need for third-party transfer. He claims that she left the place. So I was wondering if he can go to the incident location with a law enforcement officer to verify that she is no longer there, then he can return home. That's about it, Your Honor.
All
We
right.
would like to request for signature on bond, even though it's level 3. Thanks.
All right, defendant's gonna receive $1,000 surety bond, 500 on each count. He's to have no contact with Ms. Minares and stay away from that location if Ms. Minares is still there. He can return with law enforcement one time to make the determination. If he's gone, if she's gone, he can return. If she resides there, he can collect his items. He's to have no alcohol, drugs, or weapons, and he's going to all purpose on the 13th. Is there anything additional?
Nothing further from defense, Your Honor.
All right, best of luck to you, Mr. Minish. Have a good day. What do we have next?
Number 18, Mr. Olawami. Olawami.
All right, good afternoon. Your case is 25 CR 0016. I'm sorry, 1065D. And you're charged with violating a family violence protective order. You understand your rights? All right, Mr. Howard.
Second arrest. He was arrested this year for battery DV ag assault. It's 25 PI 000375.
Okay. Ms. McCarthy.
Yes, Your Honor. This incident happened January 19th. The victim in this case is Miss Journey Darton, who does share a child with the defendant. The defendant contacted her through a mobile app called Family Wall after being released from the Fulton County Jail. for those aggravated assault and battery family violence charges Mr. Howard mentioned, they were against the same victim. There was a Superior Court order executed by Judge Manning on the 16th of January that states the defendant is to have no contact, direct or indirect, with the victim. So he was in violation of that TPO at the time he made contact. The 12-month protective order was dismissed on the 30th of this month. However, at the time that he made contact, the order was still in place, and so there was a violation. His aggravated assault and battery case, which he got a $30,000 surety bond on, states that he is to have no contact with the victim and stay away from 141 Fairview Drive in Fairborn. So he's also in violation of his bond in that case by making contact with the victim after his release. So less than 24 hours after he got out of jail, he did try to contact her. Based on this violation and the fact that he is accused of battering and trying to strangle this victim, the state's recommendation is a $3,500 surety bond, no further contact with Journey Darton in compliance with his other bond order. Any visitation of their child should be through a Superior Court order, as it does appear there is an open legitimation case. Stay away from the victim's residence, no drugs, weapons, or alcohol while out on bond. And I would just ask the court to sound for Ms. Darton.
All right, I see Ms. Darton on the line. If you wish to make a statement, please turn on your camera, raise your right hand. Do you swear or affirm testimony you give today be true to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
Well, I would just like to say that on the 30th, when I went to court for the TPO, the judge said that he was not served with the TPO. And then she asked if I wanted to continue. I told her no. Also, on his bond, it did say that he was able to contact me through Family Law. I wasn't made aware of that at the time, which is why I made the call to.
Okay.
I'm going to take a look at that bond one more time because I'm pretty sure it said no further contact, but let me verify.
I have a question, Your Honor.
No, not yet. All right, Ms. Darden, is there anything else you'd like to tell me? Or again, I'm most concerned of, I know that there are other situations going on, but if you would like to tell me anything about concerns you have for your own safety, I'm happy to listen to those at this time.
Yes, I have no concerns for my safety or my son's safety. That's all.
All right. All right, I appreciate you coming to court and making that statement. Ms. Mokake, what did you unearth?
You are to have no contact directly or indirectly, I'm reading it right now, with the victim. If you encounter the victim, you must leave immediately. Still looking.
Okay, well, we'll hear from Ms. Kim while you do so. Ms. Kim?
Oh,
Well,
sorry, Your Honor. Sorry,
That's
Ms. Kim. It does say no further contact, but he has to use Family Law for communication about the child. So she is correct. He is able to communicate with her through Family Law. So in that case.
So does that change this? I'm sure that changes the state's position.
Yes.
Yes, it does, Your Honor.
Okay, so are we going to NOD this?
Yes. I think it should be
Yes.
Your Honor.
Yes. Yes.
Yes, we will be NODing. Thank you, Ms. Kim.
All right, so the case is closed at this time. All right, best of luck to you, sir. That concludes the case.
Your case
All
is
right.
dismissed.
Next,
And I'll send that NOD to Mr. Jordan.
Thank you.
Yes.
Is that right? Okay.
next, Your Honor, is position number 22, Mr. Say.
I'm sorry, is Mr. C, is that position one?
Yes, Your Honor.
All right, Mr. C, your case is 25 CR 001068E, and you're charged with criminal trespass. You understand your rights? Is that a yes?
Yes, ma'am.
All right, Mr. Howard?
12 on probation for shoplifting. 2024 theft by taking, 2022 probation, 2021 FTA, 2019 failure to appear, trespass, giving false name conviction.
Okay. Ms. Mokake?
This is position 22.
Uh-huh.
Okay. This incident happened at the Wesley on Beltline Apartments at 370 Northside Drive in Atlanta. A courtesy officer at the apartment complex responded to a noise complaint in apartment 2244. This apartment had been vacant since September 15th of 2024. Upon arrival, they met with the defendant and two other individuals. The defendant had previously been found squatting in the apartment on February 20th of this year and had been given a criminal trespass warning at that time. Based on his history and the fact that he was previously told not to return to this location, we would ask that his $1,000 surety bond, which he currently has, remain the same, that he stay away from that incident location, no drugs, weapons, or alcohol while out on bond.
All right, Ms. Kim.
Yes, Your Honor. My client is 45 years old and he was born and raised here in Georgia, Your Honor. Last 3 years, he has been having very difficult time with his financial situations, including homelessness. And Your Honor, he is a veteran who was discharged 2009 and he was serving for our country and Navy. He does have a good mailing address. He's going to use his mom's place as a good mailing address, and he will be getting his housing through the VA. He's kind of like on the waiting list to get that, so it will solve his problem about like criminal trespass. We would like to request for signature on bond. He's recommended for number 2, pretrial level 2. I really think he needs one more chance to settle down. Thank you.
All right, the bond will remain as set at the 1,000 surety. He's to stay away from that location, have no alcohol, drugs, or weapons, and he's going to all purpose on the 13th. Is there anything additional?
Nothing further from defense.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position number 26, Mr. Wade.
All right, Mr. Wade, good afternoon. Your case is 25 CR 001072J. In this case, you're charged with battery family violence. You understand your rights? Is that a yes? All
Six
right,
total.
thank you.
On probation out of Walton County, armed robbery, ag assault. 2017 probation, 2012 unprohibited item by inmate conviction, and he has a hold out of somewhere, but he got a hold. It's on Odyssey.
Okay. Ms. Mokake?
Yes, Your Honor. This incident happened at 11-4 Maury Avenue Southeast in Atlanta. The victim in this case is Miss Shaquan Hawes, Hawes. The parties used to live together and used to be in a relationship. The victim told officers that the defendant had moved out since their breakup, but he had come back over to the house to discuss getting back together with her. The victim told him no, and he became upset and proceeded to strike her across the face, causing bruising and swelling to her cheek. The state's recommendation is a $2,500 surety bond, that he have no further contact with the victim, that he stay away from that location, no drugs, weapons, or alcohol while out on bond, and I would ask the court to sound for Ms. Hawes.
All right, is Ms. Hawes present? Wishes to make a statement? All right, Ms. Kim?
Yes, Mr. Wade is 43 years old, and even though he was born in Kentucky, he lived here in Georgia all his life. He has his family members here, his mother's here, but he is not employed right now. He was doing antique dealership with his uncle. However, his uncle passed away about a few weeks ago, and ever since then, he has been not being able to have a job right now. So he's actively looking for one. He has education up to 9th grade. He completed his GED in 1998, and we would like to request for signature on bond through pretrial level 3, even though he's only required for recommended for a pretrial level 2. He does have a Walton County hold, so he will still be here in Fulton County Jail until they come and pick him up. So we would like to request him to get a signature on bond.
All right, defendant's gonna receive a $1,500 surety bond. He's to have no contact with Ms. House, stay away from that location, have no alcohol, no drugs or weapons, and he's being reset to state all purpose on the 13th.
Thank you.
Is there anything additional?
Nothing from defense, Your Honor.
All right, that's good luck to you, sir. Who do we have next?
Next, we have position number 6, Mr. Cox.
All right. All right, Mr. Cox, your case is 25 CR 001058J. In this case, you're charged with battery family violence. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
He's out on pretrial for simple battery. It's 24 CR 004558J on probation, sale of marijuana out of Forsyth County. His history, he got burglary, armed robbery, terrorist threats, convictions. That's it.
He's 15 years old. He's
All
18.
right. Mr. Rose, please proceed.
Yes, Your Honor. As it relates to this particular case, September 29th of 2024 at 3:18 p.m., Officer Kaiser responded to 2576 Martin Luther King Drive Southwest, unit number C202 in Atlanta, Georgia. There was a fight in progress. Miss Brittany Hughley told police that her boyfriend, Derechino Cox, that she was in the process of filing for an eviction to have him legally removed from the home. And when she told him that, he became angry and agitated over that conversation. Ms. Hughley stated that the argument quickly became physical and that Mr. Cox pushed her down to the ground multiple times, spat in her face, poured water over her head, and punched her with closed fists multiple times upside her head and face. Ms. Hughley complained about swelling and soreness to her head and face, and officers did observe the swelling to her head as well. She did not receive medical treatment on the scene, and Ms. Hughley and Mr. Cox were in a relationship for 4 years, and they do in fact share a child together. Our office have been in contact with Ms. Hughley, and she states that what's alleged in the warrant is in fact correct, and she states they're no longer in a relationship. So at this juncture, Your Honor, given the criminal history that was told by pretrial, Mr. Howard, and I also show that he has a total of 21 cycles on his GCIC. We're asking for a $5,500 good bond and no further contact with Ms. Brittany Hughley, and to stay away from 2576 Martin Luther King Jr. Drive Southwest, specifically apartment C202 in Atlanta, Georgia. Thank you, Your Honor.
All right, I'm going to sound for Ms. Hughley. All right, hearing none, Ms. Bader, please proceed.
Thank you, Your Honor. Mr. Cox is 33 years old. His birthday was yesterday. He's been in Atlanta his whole life. He has been gainfully employed, actually with the same employment for 11 years. He works as a bulldozer operator, designs backyards, driveways. Judge, he vehemently denies these allegations. They do share a child together, and she is currently pregnant. They have another child on the way. We are objecting to the no contact since they do share children. We would ask for no further violent contact. However, we will not object to the stay away. He can live with his mom and aunt. His family's in Atlanta, and he can live with them. So we would ask respectfully for no further violent contact, but we would not object to the stay away. And Judge, we're asking for ideally a signature bond, but otherwise for the bond not to exceed $1,000 good bond. Thank you.
All right, defendant is going to receive a $2,500 surety bond. He needs to have no contact whatsoever with the alleged victim. At this time, of course, contact can be revisited or amended. He is to stay away from that location. Should he need to return, he can do so one time with a member of law enforcement. And he needs to have no alcohol, no drugs, no weapons as a condition. Sir, I see that you have your hand raised. It's my strong advice that you allow Ms. Bader to represent you. Do you have a question about the bond as I just said it?
Yes, I feel like that's over exceeding from what I can pay for and her allegations towards for what she said I did.
Okay.
There's a big video camera in front of our house.
Okay. Please let Ms. Bader know all of those exculpatory facts, okay? We're not, the case is not being tried today.
Oh, Judge, I'm sorry, I did fail to add that this warrant is from September 29th of 2024.
I'm aware.
Okay.
All right. So, you know, in light of that, I'll make it 2,000. I'll reduce it slightly. All right.
So
All right. Best of
how can I get my how can I go by? 'Cause I had too many kids with her and my house, her house, which is her name, is furnished with my stuff. The only thing she got at hers is her kids stuff. I was talking about, I need all my stuff. If I can't get out at least far enough, can my mother, Nicole Lee, which is on video
We
now,
can arrange a third party, they can coordinate third party transfer of his items beyond the date, but that would be it, okay? All right. All right. And of course, contact can be revisited at a later date. For now, that's what it'll be. All right. Best of luck to you, sir. That concludes your case.
Next, we can go to position number 24, Mrs. Smith, y'all can go.
Go to my arm myself.
So you gotta wait for somebody to take you back. Have a seat, sir.
Okay. Let's see.
Who is this?
All right. This is Wayne Smith, correct?
Yes, Your Honor.
All right. Mr. Smith, your case is 24 CR 001070H. In this case, you're charged with public drunkenness, obstruction, and simple battery. Do you understand rights?
Yes.
Mr. Howard?
40, 2024 FTA, 2020 simple battery conviction, 2019 disorderly conduct conviction, 2017 simple battery conviction, 2015 trespass terrorist threats conviction, 2014 parole violation and trespass conviction.
All right. Ms. Mokake?
I also had a 2024 arrest for possession of a Schedule II controlled substance. This incident happened at the Five Points MARTA station located at 30 Alabama Street in Atlanta. Officers observed the defendant drinking an alcoholic beverage on the southbound platform. He was in an intoxicated condition and was using profane language when officers approached him. Due to him not having his identification on him, officers told him that he would be placed under arrest. When the officer tried to handcuff the defendant, he tensed up and backhanded the officer's right hand and pushed him, then took flight towards the escalators. Given his history, the state's recommendation is a $1,500 surety bond. That history does include an FTA, and it does raise some concerns that he will reoffend. Stay away from that 5 Points MARTA station. No drugs, weapons, or alcohol while out on bond.
Ms. Kim?
Yes, Your Honor. My client is 64 years old. He was born and raised here in Georgia. He has been in the Navy military. He's retired from that. I guess he started serving 1980, Your Honor. He does have a good phone number and address. We would like to request for a signature on bond through pretrial level 3 or the maximum $1,000. Good bond for all three charges. Thanks.
All right, defendant's gonna receive $1,000 surety bond broken down as follows: 250, count 1, 250, count 2, 500, count 3. He's to stay away from that MARTA station, have no alcohol, drugs, or weapons, and he is also going to all purpose on the 13th.
Thank you.
All right, can we do position 18, please? I mean, sorry, position 19, please.
We
Mr.
can.
Perez?
Come on, Mr. Perez.
Lucia, will you please raise your right hand for me and come on to camera?
Sarah.
Lucia, hello?
Yes, Your Honor. Sorry about
Oh,
that.
that's okay. Make sure
I
you
was
heard
with-
me.
I lost my keyboard there for a second.
That's okay.
Um,
You're fine. Do you swear and affirm that today you will make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
I do, Your Honor.
All right. Thank you. Good afternoon, Mr. Perez. Your case is 25 CR 001066Y.
Last name, be quiet, please.
Buenas tardes, señor Pérez. Su caso es el 25 CR 001066Y.
All right. In this case, you're charged with battery family violence with the offense date of December 25th of 2024.
En este caso, usted tiene la acusación de violencia doméstica con el hecho ocurrido el 25 de diciembre del 2024.
You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you.
Tiene todo el derecho de permanecer en silencio. Cualquier cosa que usted diga puede ser y será usada en contra suya.
You have a right to an attorney, and Ms. Kim is here to represent you today.
Usted tiene derecho a un abogado y la señora Kim está aquí como defensora pública para representarlo el día de hoy.
And as you can see, I'm conducting this hearing by video. Do you understand your rights and how I'm conducting the hearing today?
Y como usted puede ver, esta audiencia está siendo hecha por video. ¿Entiende usted sus derechos y acepta el hecho de que estemos por video? ¿Perdón?
Sí.
Yes.
All right, Mr. Howard, can I please have the history?
Oh, I thought she was going to fourth arrest. All he got is a bunch of stuff dealing with driver's license. That's it.
Y la juez pide sus antecedentes. Le dicen que este es el cuarto arresto, pero que todo lo que usted ha tenido antes tiene que ver con licencia de conducir.
Correcto.
Correct.
All right, Ms. Mokake, please proceed.
Your Honor, this incident happened on December 25th of last year at 1715 Summit Place Drive in Sandy Springs.
Ahora el de la fiscalía indican que este evento ocurrió el 25 de diciembre del 2024. La dirección es el 1715 de Summit Place en Sandy Springs.
Correcto.
Correct.
The victim in this case is Ashley Hernandez. Her and the defendant both live in the same location.
La víctima en este caso se llama Ashley Hernández y usted tanto como ella viven en el mismo lugar.
Correcto.
Correct.
The parties were having a verbal dispute that turned physical when the defendant hit the victim in her nose. Officers noted that her nose was visibly discolored.
Los dos estaban teniendo un desacuerdo, un argumento y le pegó a la víctima en la nariz. Los agentes de policía observaron que la nariz había estado golpeada y había mala coloración.
Sí, yo traté de defenderme.
Sir, don't comment on everything. Just wait till the end and let your attorney talk for you, okay?
Señor, no tiene que comentar en todo, no son preguntas para usted, son nada más los hechos y su abogada va a hablar por usted.
Our office has spoken with Ms. Hernandez, who states that everything in the warrant is correct. She states that she does not fear the defendant.
Nuestra oficina se ha comunicado con la señora Hernández, la cual dice que todo lo que está en la orden es correcto y que ella no tiene miedo de usted o de que usted regrese.
However, she states this is not the first time the defendant has been violent with her. She states that she has pictures of injuries to her lip, eyes, and knees from a previous incident.
Sin embargo, esta no es la primera vez que el acusado golpea a la señora. Ella tiene fotografías de golpes en sus labios, ojos y rodilla.
She states that she attempted to file a report, but the defendant snatched and broke her phone.
Ella dice que ella intentó hacer un reporte, pero que el acusado le arranchó el teléfono.
She says she would like the defendant to get a alcohol evaluation, counseling, some anger management. She does want to stay away, but she wants no further violent contact.
Y lo que ella quiere es evaluaciones de alcoholismo, tratamiento de alcoholismo, que permanezca lejos de ella y puede tener contacto, pero no contacto violento.
The state's recommendation is a $2,000 surety bond, no further contact, given the fact that the victim told our office this is not the first time he's been violent with her, and this is not the first time she has sustained an injury.
La recomendación de la fiscalía es una fianza asegurada, de $2,000. Una orden de no tener contacto con la persona agredida porque este no es la primera vez y porque existen fotografías de las veces anteriores.
Stay away from that incident location. No drugs, weapons, or alcohol, and any other conditions the court might find appropriate, such as anger awareness.
Que no puede regresar a esa misma ubicación, al mismo lugar, que durante el tiempo que esté en probatoria no puede consumir alcohol, drogas o cargar armas. Y esa son lo que pide la fiscalía más cualquier otra cosa que la juez determine, especialmente para manejo de la ira.
Ms. Hernandez did indicate she wouldn't be able to join the Zoom because she's working, but I was just asked that she be sounded for out of an abundance of caution.
La fiscal indica que la señora Hernández no pudo estar aquí el día de hoy porque estaba trabajando, pero se pide que se le llame por si acaso haya llegado. Would you like me to do that?
Yes, will you please sound for her?
Sí. Damas y caballeros, y la señora Ashley Hernández, se encuentra en el Zoom o en el tribunal, en el Zoom, por favor, abra su micrófono y su cámara.
All right, hearing none, Ms. Kim.
Yes, Your Honor. My client, Mr. Perez, was born in Guatemala, came to U.S. When he was 13 years old.
Ahora su abogada defensora es el turno de ella e indica que el señor Pérez nació en Guatemala, vino a los Estados Unidos cuando tenía 13 años de edad.
He has lived here in Georgia 9 years and he's only 22 years young.
Él ha vivido aquí 9 años y tiene 22 años de edad.
And this is his first violence-related offense. We would like to know if we can get signature on bond, no matter how much level it is, level 3.
Esta es su primera ofensa violenta y quisiéramos pedir a su señoría una fianza nada más con firma, no asegurada.
He has been working at a construction company for the last whole year, and he does have a 9th grade education.
Él ha estado trabajando en una compañía de construcción los últimos 4 años y él tiene una educación de hasta el 9º grado.
And he's pursuing GED, and I was wondering if we can refer him to a LADDER program, LADDER, a pre-diversion program.
Él está estudiando actualmente para sacar su diploma equivalente del colegio y queremos ver si podemos referirle a un programa que se llama LEDDER, LEDDER.
And we have no objection to a stay away and no further contact.
No tenemos ninguna objeción de permanecer lejos del lugar, de la dirección y de no tener más contacto con la víctima.
All right. Defendant is going to receive a $2,000 signature bond through pretrial services at level 2.
Y el fallo de la juez es, el acusado va a recibir una fianza bajo firma nivel 2 por medio de la oficina anterior a juicios por $2,000.
I'm sorry, Miss Mokake, remind me again what the victim's wish was. She wanted no further violence, but the state's position was no further contact.
Yes, no further violent. And then she also asked for a stay away.
Okay. All right, so defendant is going to have no further violent contact with the alleged victim, but he is going to stay away from that address.
El fallo de la juez incluye que no puede tener contacto violento con la víctima, nunca más, y que debe permanecer, la orden es que permanezca lejos de esa dirección.
He can return with law enforcement one time to get any of his items.
Puede regresar una sola vez acompañado de agentes de la ley o policíacos para sacar sus pertenencias.
He's going to take the one-day anger awareness course.
Va a tomar una clase de un día completo para manejo de la ira.
And he is to have no alcohol, no drugs, no weapons.
Y no puede beber bebidas alcohólicas, drogas o poseer armas.
Is there anything additional from State of Defense?
No, nothing further from
Okay.
defense, Your Honor.
Oh, he has a question. Sir, what is your question? Is it just about the bond?
Tiene una pregunta, señor, tiene una pregunta únicamente de la fianza.
If it's anything beyond that, you should probably speak to your attorney.
Porque si es que nos quiere decir algo más, es algo que debió haberle dicho o puede hablar con su abogada.
Ok, está bien. Tengo una pregunta con la fianza. ¿No me la podrían bajar?
I do have a question about the bond. Is it possible to have a lower bond?
I'm allowing you to sign your own bond. You're going to sign a signature bond. I'm essentially letting you out of jail without payment, but you must report to pretrial services.
Eso no quiere decir que va a pagar. Le está dando esa fianza por esa cantidad, pero puede salir de la cárcel nada más firmando. Pero necesita presentarse a unas oficinas que le van a decir que son los servicios anteriores a juicio. Ahí es donde usted puede saber más sobre la fianza, pero le están dejando salir bajo fianza de $2,000 únicamente con su firma.
Está bien, muchas gracias.
Okay, I understand. Thank you very much.
All right, that concludes your case, Mr. Perez. Lucia, will you sound to make sure no one else needs your help?
Yes. Damas y caballeros, si hay alguien más en la llamada de Zoom que necesite un intérprete en español, por favor, déjeme saber.
Hearing none. Thank you, Lucia, for jumping on at the last minute. Have a good weekend.
Thank you, Your Honor. You do the same.
All right, bye-bye.
Bye-bye now.
All right, who do we have next?
Number 9, Mr. Hearn. Number 9, Mr. Hearn.
Mr. Hearn, your case is 25 CR 001060E. You're charged with theft by shoplifting. You understand your rights?
Yes, I do, Your Honor.
All right, thank you, Mr. Hearn.
15, resident of Michigan, got an FS charge of robbery. I think they gave him a 6,000 good bond, I think. 2024 FTA out of Florida. 2024 petty theft conviction. 2020 assault battery conviction. 2021 retail fraud conviction.
This is the one that needed to be interviewed. Did you have a chance to interview him, Ms. Spader?
I did speak to him, Your Honor.
Okay, understood. Thank you. All right, Mr. Rhodes, please proceed.
Yes, Your Honor. As it relates to Mr. Hearn, I believe that this was an incident that took place somewhere between November 24th of 2024 or December 28th of 2024. Basically, Costco is equipped with digital surveillance, and they went back. They had a team to go back and look at surveillance thefts, and in between that time, they observed the defendant come into the store with a dog on multiple occasions. Let me make sure I'm looking at it. Forgive me. Give me. Yeah, this is Daniel Hearns. Is that correct?
That's correct. We don't know the day, but there's an approximate day.
And if I may,
believe that this one occurred on December 28th of 2024, but they did the surveillance between November 24th of 2024 and December 28th, 2024. When they looked at the surveillance on December 28th, 2024, what they saw was this particular defendant come in with a pit bull puppy and commit the crime of theft, where he had taken a jacket. I believe it was a I'm not mistaken. No, this is a different. I believe he removed a bottle of Hennessy from the shelf on that particular day, and this happened at 6350 Peachtree Dunwoody Road. It's of the opinion that I thought I'd read about a it might have been a bottle of Hennessy, Your Honor. As it relates to this particular case, we're asking for a $2,000 signature bond, pretrial services level 2. I don't know why I thought I read about a North Face jacket, But anyway,
No,
and
that's,
that he stay away from 1165 Perimeter Center in Sandy Springs, Georgia,
That's Costco.
which I believe is the Costco, Your Honor. And that something about a jacket valued at $400. Maybe it was a jacket and a bottle of Hennessy, Your Honor. I can't recall.
So the offense date, Mr. Rhodes, is not this date that's listed. It's a different date, and they went back and reviewed the tapes. Is that what you're saying?
That's what I'm seeing, Your Honor, on the warrant. I'm showing that it says this occurred on December 28th, 2024, pursuant to Costco's equipped digital surveillance camera is when they actually saw it. So,
Okay, and so the offense date of November is, so should we change this offense date? Or did they look at it on the 28th and figure out that the offense date was November? I'm just trying to figure out where we got November.
because it says between November 24th at 12 p.m. and 12/28 at 1 p.m. So they could have looked at it on 12/28 and the offense date was 11/24. That's correct, John.
Okay, we have 11/21, so there's still further discrepancy. Okay, well, so some date that may not be on here.
Oh,
All right.
I'm sorry. I'm looking at two different, and that's the issue. There are two different warrants, Your Honor. There is a November 21st, 2024 for theft by shoplifting, and this is what we're here for. It was for the
jacket.
The jacket. It was a North Face ski jacket that was valued at $400.
Okay.
I just think so. What happened was between those dates, they saw him selling a couple of times.
Okay.
Yeah, but this particular theft was for the
first one, for the jacket. Okay, understood. All right, thank you for that point of clarification. Ms. Bader?
Yes, Judge. We don't object to the signature bond. I just wanted to note that there is probably confusion because the felony warrants are rather similar. Actually, the felony case has a misdemeanor shoplifting, so I just wanted to make sure there aren't duplicates of this particular case. If we want to, we don't object to the signature bond at this juncture.
I'm not sure he's, what was it, Mr. Howard? It was, what was the year for the robbery?
He went to court today for that. And he's a resident of Michigan.
Yeah, I don't think he can go through pretrial. And with that robbery in his history, I don't think he's eligible for that signature bond. Let me look at something really quickly. And so this offense, I just want to clarify, this is the 11/21. He's accused of taking a jacket.
That is correct, Your Honor.
And the robbery may, and so are we able to see if this is a duplicate case? Or if this is attached to his felony case before we do anything else?
Yes. And is it out of Fulton County?
I believe so. I think that's what we just heard.
I'm looking now, Your Honor.
So he went to felony today for robbery and shoplifting.
Right. So the incident date on the felony case is 11/24/2024. So the case is 25 PI 001598. So they didn't touch this one.
Okay, so this is totally separate. Okay.
So it's two different locations and two different incident dates.
And this one predates the one that he went to felony for.
Correct. Yes. So the location on this warrant is 1165 Perimeter Center West, Atlanta, Georgia.
Okay, and so it's still that same Costco.
Right. So it's just I don't think it's a Costco. I think so. The felony case was at a Costco. This was at a different location, but the same officer did both warrants.
Both warrants.
So he wrote the write-up the same on all three warrants.
Yeah. Okay. The weird thing though is that he did a November 21st theft by shoplifting, the North Face ski jacket, but the robbery indicates, I'm looking at the warrant for the robbery, Your Honor. Says said accused did unlawfully with intent to commit a theft, from the person in immediate presence of Eric Chandler by entering the Costco liquor store located at 6350 Peachtree Dunwoody Road in Sandy Springs, Georgia, and remove a bottle of Hennessy from the shelf. Said accused then concealed the bottle in his clothing and attempted to leave the store. Victim Chandler recognized said accused from 11/24/24 incident, attempting to detain said accused with pepper spray Chandler and then fled the store. The value of the bottle of Hennessy was $77.98. So he took the Hennessy from the shelf, but they did a robbery. Guess it was in the immediate presence of the security.
You pulled out a knife out on me.
What bond did he get on felony? What felony bond did he get?
He got 5 on the robbery and 6,000 good. 5 on the robbery, 1 on the shoplifting.
Okay. All right. And so this one predates, so technically this would have been his first. I'll stick with the $2,000 signature bond through the jail with the conditions that he stay away, have no alcohol, drugs, or weapons. It sounds like he still has some felony things to sort out. All right.
Thank you, Your Honor. Sir, you got a signature bond on this
Please,
case.
yeah, please don't say anything else. You guys signature bond against some of my better judgment, okay? I went with the state, so just please don't say anything else. Just roll
Mine
with
too,
it.
Your Honor.
Just roll with it, sir. I'm letting you out. I don't understand why you're upset and confused. There's nothing left to be upset or confused about. I'm letting you out, okay? So all right, this case is not holding you.
Yes.
Oh, look, a gift horse in the mouth. All right, who do we have next?
Number 13, Mr. Jordan. And the quorum is empty, Your Honor.
It is. Is this our last case?
Yes. Yes, it is, Your Honor.
Real quick, Honor, did we do position 20? Did I
Is there a
just miss-
Marquis King?
Oh, there's waivers,
Okay.
Yeah.
but this is our last physical case.
Okay. All right, can we stop the live